Hello everyone. So this is going to be a lecture about the sources of English law. Where does law come from? Well, there is an aspect of it which means it comes from the decisions of judges. That's what common law is really about. What's quite distinctive about common law. Case law, we sometimes say, as in the rulings that courts have made in particular cases. There's also legislation by Parliament and other legislatures. We call such laws passed by Parliament and other legislatures statute. And obviously there's the law of the European Union from 1973 onwards, but of course from 73 to 93 it was called the European Economic Community. Anyway, parliamentary legislation became increasingly important in the 19th century and 20th century as more and more of it was passed. Just trying to find my right place in my notes here. So these acts of parliament are passed, statutes as we often refer to them, and there's sometimes primary legislation saying this is the law. Sometimes there's secondary legislation. The primary legislation delegates the power to another body to actually make law in more detail. That's the secondary legislation, but ultimately it's part of the parliamentary authority. So statutes, they're documents, and you can find them online. You can buy them from the government, from Her Majesty's Stationery Office, and the statutes start out as bills, as in proposals, which are debated by the House of Commons and the House of Lords. They've got to be passed thrice in each house to become legislation. They usually originate in the House of Commons. They occasionally start in the House of Lords. But once a statute has been passed by Parliament, received the royal assent, the golden words "La reine le veut," as the Queen wishes it, then it is the law. But if a statute were to clash with European law, then it could be struck down. So that's a seminal moment. Prior to that, it was established that courts could not strike down statutes in the United Kingdom. In other jurisdictions, it's different. For instance, the Republic of Ireland. So there are two major categories of acts of parliament. There are private acts and there are public acts. A private act, sometimes called a personal act of parliament, is one which pertains to a certain location or a class of people. So this is usually coming from a big organization or a county or something like that, or a corporation asking to be granted particular powers. A local authority might ask to build a bridge. If you go back to the 16th century, there are loads of acts of parliament like that. Even divorce has had to be acts of parliament. Enclosures of land had to be acts of parliament. Things of that nature. Monopolies for people were acts of parliament. So those who wishes to get this act of parliament passed has to persuade parliament that it's useful and valuable. Most acts are public acts, and these are about the common weal. So they're debated in both houses, as you'd expect, and anybody else can present his views on the matter. So people lobby politicians to try and persuade them to vote one way or the other. Anyway, so there are very few private acts these days. So public acts sometimes are divided into government bills, as in the governing party puts them forward, particularly the front bench, the cabinet, or in private members' bills, which quite often come from an MP at an opposition party, or could be a backbench MP of the governing party. So when a bill is a government bill, then it's drafted by the government's own draftsman, could be a draftswoman, who draws it up in the correct legal language. And there'll be a green paper, which is a discussion document, followed by a white paper, which is what the government policy is. Now, not all these bills actually make it to become acts. Private member bills are the pet projects of backbench MPs of either side of the House. And these more commonly take their life, first of all, in the House of Lords. So parliamentary sovereignty applies to every act of parliament. And remember the British Railways Board and Picken, they celebrated a case of 1974, which I mentioned in a previous video. So there's some consolidated acts which clear up a confusing situation about statute law in a certain area, and they sometimes bring them together in a single act. Sometimes repeat existing acts might remove particular provisions. There are codifying acts, which enact statute rules that until that point were only found in case law. Say this is not just case law, it's now statute. What is the legislative process? Well, the bill is introduced in either house, but usually the House of Commons, except for money bills. Remember, the House of Lords has no say on money bills, no power to delay them because of the Parliament Act. So they have to pass through a number of stages and eventually end up as statutes. So there's the first reading, which is just going through the motions. The title and date is read, ready for its second reading. The second reading is a vital moment, and the main principles of the bill are debated and amendments are proposed, and then people vote on it at the end of the second reading. And there's a committee stage. There's a committee which is experienced in this particular area, and they look at it in great detail, and less partisan. There's smaller members, so the committee is made up to reflect the strength of the different parties in approximate proportion to their number in the House of Commons. For instance, if it was today, they said there were 10 committee members, there would be 6 Conservatives, maybe 3 Labour, and 1 from another party, either the SNP or the Liberal Democrats. Anyway, the committee stage then might change the bill a bit to give it a better chance of being accepted. The thing is, if the bill is really important, the whole House forms a committee. The trouble is, this makes crucial bills slower. Then there's the report stage. The committee draws up a report, and the House will debate any amendments. Are they going to tweak it, put in this amendment or not, and then vote to them. There's the legislative stage. This is for bills which only apply to England, or sometimes England and Wales. So the Speaker of the House of Commons has to sign off on the government bill or the provisions in it which apply to England solely or England and Wales, not to the United Kingdom in its totality. If these fall within the legislative competence of a devolved administration, such as Northern Ireland or Scotland, that's different. Okay, so if the people don't vote for this because of the bill in the whole House, it fails, the bill is defeated. So sometimes the bill is passed, but certain provisions are not, so it could go through partly. The third reading is when the bill goes to before the entire House, and it's either passed or it is blocked. So the whole process has gone through in the House of Lords. As I say, it usually starts in the House of Commons, and it could be amended in the second House. The government could be defeated, sent back to the House of Commons. Are they going to be accepted or rejected, these amendments? If there are particular provisions relating it to only England or indeed England and Wales, then that's different. Remember, the House of Lords can't delay even a money bill. That's as per the Parliament Act of 1911. So the royal assent is the last stage. Now, oddly enough, there's no legal rule that the monarch has to assent to these. However, since the reign of Queen Anne, she died in 1714, the monarch has always signed these bills. Even, say, the India Act, which George III absolutely detested, said anyone who votes for this will be my enemy for life. He still signed it. So people think that the royal assent is the merest technicality. And the Royal Assent Act of 1967 actually said that. So commencement. Then the Act of Parliament kicks in from the day it receives a royal assent, unless it says otherwise in the legislation. Usually there's, quite often there's a delay saying, oh, well, it's not going to take effect for some time to get used to it, like, say, raising the smoking age to 18 or something. So the Secretary of State with responsibility for this particular area of activity might issue a statutory instrument which will say that the bill has now, or the act has now taken effect. So there's also delegated legislation. When it's delegated to other bodies, we sometimes call this secondary legislation or indeed subordinate legislation. And that can be made by another body or another individual outside of Parliament. And this might include some regulations which are provided by statutory instruments such as orders in council or bylaws. Bylaws are local laws. Any properly enacted piece of legislation has a statutory effect, the same as any act of Parliament. So lots of laws are enacted through delegated legislation, much more than the number of primary acts of parliament. They say that 99% of the new laws passed in 2014 were made through statutory instruments. There were 30 general acts passed by Parliament and 3,500 statutory instruments passed. So there's just a staggering amount of law. Nobody could possibly get their head around it. So this has led to creating too much delegated legislation. Well, some people think too much. For instance, the Fatal Accidents Act of 1976 allows a claim to be made for damages in terms of bereavement, paid compensation. Section 6 of that still says that the Lord Chancellor is able to amend the statutory sum, make it greater or lesser. So because of that, the statutory sum at the moment is £3,500. They can be claimed it's been increased, and well, it was increased and increased eventually up to £12,980 because of the damages for bereavement variation of sum. We're not going to give you all the numbers at the end of it. So there are some good points about this delegated legislation because it speeds things up, and passing a bill through Parliament, as you have garnered, is time consuming. So because there's so much debate, but people say hard cases make bad law, we shouldn't rush it through, we should meditate and pause, and we don't want legislative hyperactivity. Like, go back to ancient Athens, anyone who proposes a new law must do so with a noose around his neck. If it's rejected, you'll be hanged, is the idea. So we don't want rules that we don't need. Let's only have rules which are really worth enforcing. Let's not overburden ourselves with too many laws. So delegated legislation is rather technical, and so those who are expert in this area, they can figure out the minutiae of the law, so perhaps that's a more sensible use of time, and they can rapidly respond to a fluid situation. But the downsides of these is that these people who are not democratically accountable are making law, and there's just too much law, as I was already saying. So it's just a mere formality passing these laws. Anyway, we ought to debate these things properly. Right, so remember, you can get all these things from Her Majesty's Stationery Office, a hard copy or online. That's part of the Office for Public Sector Information, and you can find some of it in the National Archives. So back to common law. We know we've had acts, statutes, they're usually the same thing, and the judges have to read these texts to figure out what the law is, and then they would apply these to the factual case before them. So remember, there's a doctrine of precedent. They have to look at the decisions that were made beforehand and try to be as consistent as they can. This is very tricky, particularly doing justice in each case, having regard to the relevant facts. Common law, remember, can be overruled by an act of Parliament, saying, well, these rulings have been made, but no. Remember, parliamentary supremacy is central to the British Constitution. So remember, English law is often referred to the common law system. You'll find it throughout the Commonwealth, although in places like Pakistan it's blended with Sharia law. So back to custom. There are customs which are part of the English legal system. A custom is legally enforceable sometimes if it meets the standards set out by the following test, which was established in Egerton and Harding, a case from 1975. The custom must have existed since time immemorial, as they say, as in such a long time no one could remember when it didn't apply. But really, they say 1189. Why 1189? That's the death of Henry II, a great legal reformer. It should have never been interrupted in that time period. And it's the people it affects and the area it affects must be certain, and it must not be unreasonable. But anyway, custom is not a big part of the English legal system today. So let's look at European Union law. So there were three communities set up by various treaties in the 1950s. The European Economic Community, or EEC, set up by the Treaty of Rome, 1957. The UK didn't join until 1973. So the UK is dualist, which is to say treaties it signs are not automatically part of domestic law unless they're actually passed into domestic law. Whereas France, for instance, is monist. Any treaty that France signs is instantly part of French law. There are the terms of the treaties about the EEC and the other European communities. They were incorporated into British law by the European Communities Act of 1972. And the European Communities Act says all such rights, powers, obligations, and restrictions from time to time created or arising under the treaties, and all such remedies and procedures from time to time provided for by under the treaties as in accordance with the treaties are without further enactment to be given legal effect or used in the United Kingdom. And it goes on. So Section 3 of the same Act says that any issues relating to the signification and the effect of EU law will be interpreted in consonance